Without further ado, I'll introduce our keynote speaker, Radley Balko. He's a journalist who, and I will probably butcher this, but I'll try to do him the best I can. But he is a journalist who covers a lot of criminal justice issues that we have been discussing today. For the Washington Post, he has a blog called The Watch, and I think I'm correct in saying that he was even cited by Justice Breyer in a Supreme Court dissent, which, you know, as a law reviewer is kind of like a dream. So that's, you know. It was this, yeah, but it was a good dissent, right? But yeah, with no further ado, just really happy to introduce Radley Balko, our keynote speaker.
Thank you. Thanks for the kind invitation to come out and talk. It's a little intimidating talking to all of you people because you've probably heard some version of everything I'm going to say today, but I'll try to do it in an entertaining way at least. So earlier, Liliana Segura mentioned she had been to the AFS conference. Apparently there was a booklet that was handed out at that conference titled, "So You Want to Be a Forensic Scientist!" exclamation point. And there are a couple quotes in this little booklet that I think are particularly relevant to what we've been talking about today. The first is, actually they're both from a guy named Anthony Longhetti, past president of AAFS, and the editor of the Journal of Forensic Sciences, which is, of course, AAFS's kind of main publication. So the first quote goes like this: "There is literally no end to the number of disciplines that become forensic by definition, nor is there an end in sight to the number of present or future specialties that may become forensic. The examples are many." Follow up with another quote, basically saying that the general section of the AFS, which is what, actually this is a general description in the book, but the general section of the AFS serves as the Academy's gatekeeper, always willing to consider accepting new disciplines that develop in response to the needs of the criminal justice system. So basically, between these two quotes, what you see is this is the largest kind of body, or kind of a membership society within the forensics community back in the early 80s, saying basically that we welcome any and all new disciplines. We're eager to call them forensic, to give them sort of the imprimatur of being forensic science, and we are here to sort of serve the criminal justice system. That does not sort of suggest a community of scientists willing to follow the truth where it leads them. I guess it's been emphasized quite a few times already today, but we are in a very important moment, and we're in a moment of transition on these issues. There's a lot of talk of reform, but I want to emphasize how critical it is that we get it right. DNA testing was a wake-up call. It exposed all of these disciplines that we thought were certain and told us that a lot of them weren't nearly as certain as we thought they were. It also taught us some things about prosecutorial misconduct and eyewitness testimony and various other inadequacies with the criminal justice system. But it's a wake-up call that's only going to happen once. I think it's pretty safe to say there's never going to be another technology like DNA that's going to come around and be able to sort of be dispositive of guilt in the same way that DNA testing is, that it's an absolute sort of certainty one way or the other. But the problem is that DNA is dispositive of guilt in only a very small percentage of cases, as we all know. The flaws that it exposed in those very small percentage of cases, however, are universal, right? It would be sort of naive to think that the only cases in which these flaws in the criminal justice system just also happen to be those cases that DNA testing has exposed, right, where we've seen these wrongful convictions. The danger here is that we make the corrections in the cases for which DNA is relevant by basically using DNA testing and sort of overlook all of the flaws of the criminal justice system that DNA exposed that are present in all of those other cases, right? That's the real sort of terrifying kind of M. Night Shyamalan moment in this whole debate, is where we sort of wake up and realize that, okay, we do DNA testing in all the DNA cases now, but nothing else has changed, and we didn't sort of learn the lessons from all of that. If that happens, not only will we've not failed to sort of make the most of this opportunity, that was the onset of DNA testing, but we really have made just the least of it. We've done sort of just the bare minimum to address only the most sort of glaring inadequacies. But to get it right, I think we need to fully comprehend the scope of the problem and the source of the problem. And what I want to sort of emphasize this afternoon is that the flaws that we've seen in the criminal justice system that have been exposed by DNA testing were not accidental. They weren't the product of sort of a few rogue examples or a few sort of statistical blips. That the flaws were there by design. That this was intended, what we've been discovering over the last 15 or 20 years or so. This was all by design. So to get into that, we have to sort of go back and look at kind of the origins of forensics, right? And I'm sure most people in the room are aware of the fact that most forensic disciplines were developed in police stations or in crime laboratories, not in scientific laboratories. They were designed, they were developed, they were invented, they were sort of perfected, for lack of a better term, with one specific goal, which is to help police officers solve crimes. And if you want to be cynical about it, to sort of help them obtain the evidence to support the conclusions that maybe they had already drawn in some cases. If you go back to, say, the origin of fingerprint evidence was sort of developed first in Europe. It was introduced to the United States at the 1903, 1904, maybe St. Louis World's Fair by Scotland Yard as this sort of new way of identifying perpetrators, that there's this unique identification, this unique marker that people could leave behind at crime scenes. There's some interesting other things that happened at the St. Louis World's Fair that I think are relevant to this discussion. And one of the St. Louis World Fair was sort of a celebration of what you might call American exceptionalism, and it was taken to the point of sort of celebrating white American exceptionalism. I lived in St. Louis for a while, and the fair, the city still sort of takes a lot of pride in that fair, but there were also a lot of pretty awful things that happened. For example, there was a lot of phrenology, there was a lot of pseudoscience. There were these live exhibits of native peoples from around the world where some of the exhibitors had actually gone to the Philippines and to Africa and to China and collected samples, and there's these sort of living zoos that were part of that particular World's Fair. And I bring all this up because it's sort of interesting that forensics kind of emerged during this era, kind of the progressive era, at a time when there was a professionalization of policing, there's a professionalization of kind of law enforcement in general, but there was also, the progressive movement was also so sort of eager to embrace science that it could embrace some sort of very dark sides of science. So my favorite example of this is actually Sir Francis Galton, who's the kind of the father of modern fingerprint matching, the guy who kind of started this in Europe. Galton was also the father of the eugenics movement. In fact, he coined the term eugenics. And it all sort of evolved from this idea that there were certain biological markers that not only would sort of identify people uniquely, but also that you could, these markers were also indicative of criminology in entire groups of people, right? So you get phrenology again, where you start measuring skull sizes. And my point is that not that sort of all forensic scientists are racist, obviously, but my point is that like these disciplines sort of emerge from a very interesting time where there's an embrace of science, but also an eagerness, such an eagerness to sort of exert our embrace of science and our superiority that it could very quickly turn pretty dark. So from there, we start getting into investigations of crime using these kind of professionalism, using these new techniques, some of which have some probative value, others of which are complete and utterly bonkers. And then it's now up to the courts to kind of settle it all out, to figure out which sciences are real and should be put in front of a jury and which ones shouldn't. We of course get the early cases, the Fry case, where court, I think it was a federal appeals court, not the Supreme Court, but throws out lie detector evidence. In fact, in that case, I think the guy who was running the lie detector claimed he could tell people lying just by their systolic number of their blood pressure. There was not even all the other stuff that they use in lie detectors now. And we start getting these sort of death investigation systems that revolve around these kinds of forensic disciplines. But they're presented to jurors with all the kind of sheen and veneer of actual science. But scientists, of course, as we all know, aren't actually going to get involved in really evaluating these forensic disciplines for a very, very long time. Currently working on a book with Tucker Carlson of the Mississippi Innocence Project on the death investigation system in Mississippi. And it's a system that's more or less still in place today, or it has gotten a little bit better in the last 5 years or so. But this was a system that was put in place basically in the 1920s and 1930s during the Jim Crow era as a way to sort of sweep lynchings under the table, and also to exonerate, to implicate, black people in crimes that they may probably had not committed. There are a couple of famous cases. So Mississippi basically embraced kind of a modified version of the coroner system, which is the outdated death investigation system that a lot of states still use today. I think about 24 still use the coroner system. But the coroner is an elected position. In most states, the coroner is not a doctor. It's not somebody who has any medical background or doesn't need to. And in fact, up until the late 1980s, the only two requirements to be coroner in Mississippi, or to run for coroner in Mississippi, where you had to be literate, and even that one was negotiable, and you had to have never denied the existence of a higher power. Up until about the mid-1990s, the coroner's two jobs in Mississippi were to investigate deaths and to round up stray livestock. So it sort of tells you where the state kind of put priorities in terms of these death investigations. But there's some pretty famous cases. Robert Johnson, the famous bluesman who was from Mississippi, from the Delta area, died in Greenville, Mississippi, widely suspected of being poisoned by the jealous husband of a white woman he was sleeping with. Coroner was called to the scene, did an investigation, and on Robert Johnson's death certificate to this day, the cause of death is listed as no doctor, which I don't know exactly what that means. But there was no sort of attempt to sort of see what had actually killed him. The Reverend George Lee, who was probably one of the earliest civil rights martyrs of the sort of modern civil rights era, was shot and killed in Belzona, Mississippi. He was driving down a country road in Belzona. Somebody shot him as he was driving with a shotgun, shot him in the head and killed him. He then crashed his car into a tree. Coroner did an investigation, determined that the accident itself was the cause of Reverend Lee's death, and that the metal fragments, which were actually shot from the shotgun, that they found in his head were actually the fillings in his teeth, which had become jarred loose when the car hit the tree and had somehow been thrown back into his skull. And that particular murder has never been solved. When Emmett Till was killed in Mississippi, the coroner there, you can actually still go to Tutwiler, Mississippi, where Emmett Till's body was prepared. The coroner there was so disturbed, or thought that Till's mother, who was back in Chicago, would be so disturbed by what she saw. He nailed up the coffin and told her he would give her the body only if she refused to open the coffin. Of course, she did, and we got the famous photo of Emmett Till. And then later with the murders of civil rights workers, Andrew Goodman, Michael Schwartz, and James Chaney, the federal government was so worried about the local coroner down there that they actually stationed guards outside the door, the morgue where the bodies are, because they're afraid the coroner would come in and take the body away. And as I'll explain in a minute, that fear was not completely unfounded. So this is kind of the system that's been in place for a long time. And here's the way that system works. When there's a suspicious death in Mississippi, and this is also true in Louisiana and a number of other states, officially the coroner is in charge of the death investigation. The way it works sort of in reality is the coroner consults the local prosecutor. If they decide that the death is likely the result of a crime, they send the body to a private medical examiner. This is the way it was for a long time. They would send the body to a private medical examiner along with a contract for $600, $800, $1,000, plus money for testing, plus extra money for testifying in court. Now, if you think about sort of how that system plays out, how the incentives in that system play out on the ground, let's say you're a prosecutor, you think the crime happened this way, you take the body to one of these private medical examiners in the state, he comes back and says, well, that's not the way it happened, or probably more likely, there's just not enough evidence for me to say that's the way it happened. Well, maybe that guy's probably not going to get your next autopsy referral, right? This is a system that basically selected for medical examiners, private medical examiners, who tell these prosecutors what they wanted to hear. And so, over the years, there was a guy named Stephen Hayne who moved to Mississippi in the late 80s. By the early 90s, it basically monopolized the autopsy system in Mississippi. by telling these prosecutors exactly what they wanted to hear in these cases. I remember before I kind of got into this stuff, I remember reading, I believe it was Barry Scheck's book, actually, in college maybe, and I remember him talking about a guy named Ralph Erdman. It was a medical examiner in the Texas Panhandle who was found to have done 400 to 500 autopsies per year. And I remember Scheck in his book described this as an astonishing figure, right? National Association of Medical Examiners says one medical examiner should do no more than 250 autopsies per year. If you do more than 325, they won't certify you. Erdman did 400 to 500. Hayne, by his own testimony, did somewhere between 1,500 and 1,700 autopsies per year in the state of Mississippi. He did this while holding down 2 full-time jobs, and he did them not in the crime lab in Jackson, Mississippi, but in the basement of a funeral home owned by another county coroner. Just to give you an idea, so Hayne sort of dominates. He does about 80 to 90% of the autopsies in Mississippi for 20 years, never really questioned by the courts, and of course a lot of the courts in Mississippi eventually come to be presided over by judges who served as prosecutors who used Hayne while they were prosecutors. Current Attorney General from Mississippi, Jim Hood, was a longtime prosecutor, used Hayne in a lot of his cases. So Hayne comes to dominate the system. And just to give you an example of the kind of testimony that this guy would give, it's a case called the Tyler Edmonds case that happened, I think he was convicted in 2004. This is a 13-year-old kid who was being tried as an adult for the murder of his sister's husband. The prosecutor's theory was that neither of them had the guts to kill the husband on their own, so they waited until he was asleep, and then they held the gun and simultaneously pulled the trigger, right? Maybe that happened, maybe it didn't, who knows. Dr. Hayne actually gets on the stand and testifies that he can tell by the bullet wounds in the body that there were 2 hands on the gun that fired the bullets, right? This is actually upheld by the Mississippi Court of Appeals. Mississippi Supreme Court, after some media attention, did overturn it. But they overturned it. They also said they went out of their way to say this opinion should in no way be interpreted as us calling Dr. Hayne's credibility into question, that we're just throwing out the evidence in this one case, right? Well, you know, if a guy is willing to say that in a case, right, think about all the other cases where he's given testimony that could have gone either way. It's 60-40. Maybe he's opposed by another medical examiner, but, you know, both of them could be right, none of them. Like, you know, why should we now put any credibility in what this guy says, even in all these other cases, now that we know that he's capable of giving testimony like that? Well, Hayne wasn't even the worst example in Mississippi. A lot of you probably have heard of Michael West. So Michael West was Hayne's sidekick. This was a bite mark analyst in Mississippi. He was a dentist in the town of Hattiesburg, later ran for and was elected coroner of Forest County. West becomes Hayne's sort of assistant. I think sidekick is a pretty good, probably the best description. But West, you know, Hayne would give some ridiculous testimony, but he was slippery. He would give himself enough maneuverability to kind of cover his tracks. West was just bold. He would go way out of his way. West, over the years, was certified not only in bite mark matching, but also video enhancement. He claimed at one point he could tell, in several cases actually, he called it tool imprinting. So there was a case where someone was allegedly killed with a hammer, and West claimed that there were indentations in the skin of the defendant that could only have come from this particular hammer, from gripping this particular hammer. In some cases, he did this analysis of the hand, you know, days after the crime was allegedly committed. And that there were cases where there were scratches on a person's skin, and he claimed that he took molds of the defendant's fingernails and recreated the scratches, and that only this defendant's fingernails could have created the scratches that we found on the victim. And he was accepted in courts all over Mississippi. In fact, I think he testified in about a dozen courts, mostly in Mississippi and Louisiana. There was a case where there was a half-eaten bologna sandwich found at the crime scene. West claimed that he could tell by the bite marks in the bologna sandwich that the defendant and only defendant could have been the one who took the bite out of that bologna sandwich. West then destroyed the bologna sandwich. The case was later thrown out when the autopsy results were finally released, and they found a half-eaten bologna sandwich in the stomach of the victim. So West was sort of exposed in the early 90s. He continues to testify basically until about the early 2000s. The Mississippi Supreme Court continues to uphold his testimony up until 2007, 2008. I want to read you a quote. This is one of my favorite quotes. This is from Forrest Allgood, who's a prosecutor in Mississippi, actually was finally defeated for re-election. Allgood is the subject of a lot of these wrongful conviction cases in Mississippi, including Kennedy Brewer and Levon Brooks, two men who were convicted 2 years apart for a separate rape and murder of a toddler about a mile and a half apart. It turns out the same guy committed both crimes, but Allgood early fixated in both cases on the boyfriend of the victim's mother, and in both cases brought in Hain and West, and in both cases Hain and West claimed to have found bite marks on the victim that they said could only have come from the defendant. So not only was Kennedy Brewer nearly executed, Levon Brooks served about, 20 years in prison. Not only did both of those things happen, but if they'd actually done a real investigation after the first murder, they may have been able to prevent the second one. The guy who committed the crimes was actually on the list of suspects for the first murder. In 1992, in between these two cases, there's another case. Eddie Lee Howard was convicted of raping and murdering an elderly woman, I guess, and then I think burning her house down. Was accused of all this. Basically, the only evidence against Eddie Lee Howard was bite mark evidence. Again, Hain and West were brought in to provide this evidence. And I want to tell you, there were already questions being raised about West in some areas of forensics. And I want to tell you what Forrest Allgood said in his closing arguments to the jury in the Eddie Lee Howard case. Keep in mind, Eddie Lee Howard is still on death row in Mississippi. Here's what Allgood said. Whether we like to think so or not, the progress of mankind has been carried forward on the backs of people like Michael West. The church threatened to burn Copernicus because he dared to say the planets didn't revolve around the earth. So it was with Michael West. So, in addition to mistaking Copernicus for Galileo, Allgood is defending this guy to the jury. The jury buys it. They convict Eddie Lee Howard. He's been on death row ever since. I wrote about a case several years ago we found in Louisiana. So Hain and West sort of monopolized the autopsy system in Mississippi. Then they start moving into Louisiana. They were recording their autopsies and actually sending video of their doing these autopsies to prosecutors in Louisiana to sort of advertise their services. In fact, they were also taking out ads in local publications. And we got a hold of one of these videos, and it's the case of Jimmy Duncan, who's accused of raping and murdering, again, the daughter of his girlfriend. He claimed that she drowned in the bathtub. At worst it was some sort of negligence. But they claimed to have found bite marks on the girl that they said could only come from Duncan. Well, we found video of West doing one of these examinations, right? And in the video, it opens up and you see the corpse of this little girl. And you look at her cheek and it's completely clear. There's nothing on it. That's when West first gets the body. It cuts out, comes back, it's 24 hours later. Now there are these red abrasions on the side of her cheek, right? Well, abrasions don't occur after death, right? If I'm wrong, I'm sure someone in here will correct me. But bruises can, but generally not abrasions. And we see later in the video how these abrasions happen because West then takes a dental mold from Jimmy Duncan, the defendant, starts repeatedly jamming it into the girl's cheek over and over and over again. Does the same thing on her thigh. Then in court, was prepared to then testify in court that these marks on the body could only have come from the person who made this dental mold, whose teeth made this dental mold. I showed the video to several forensic analysts who basically said he created those bite marks, like that's how that happened. And now we have other videos in other cases where he's shown doing the same thing. I bring all this up because to this day, West's testimony is still being upheld in Mississippi courts. In the Eddie Lee Howard case, the last time, actually, let me back up just a little bit. Chris Plourd, whose name was invoked earlier, an attorney from Arizona who's playing a pretty prominent role in the forensic reform situation right now, had a bite mark case in Arizona in the early 2000s. His client was convicted based on bite mark testimony, was exonerated 10 years later. Plourd was really angry about this. Decided he's going to sting one of these bite mark guys. So he takes the photos from the crime scene in his client's case, a photo of the victim's breast that had a bite mark on it, and he has his investigator send a letter to Michael West. And the investigator in the letter says basically that he's the attorney for the parents of the victim in this case, and here's the photo from the crime scene of the bite mark. Here's a dental mold of the person we think did it, and here's a check for your retainer. Can you match these up? Well, he sent him his own dental mold, right? The investigator did. West not only does he say he can match this dental mold to this photo from the crime scene, he also sends back a 40-minute video in which he meticulously goes through his process, and a process that leads him to conclude that it would be astronomical. The odds are astronomical that anyone other than the person who supplied this dental mold could have left the mark in this photo. Fast forward, Eddie Lee Howard is appealing to the Mississippi Supreme Court, or post-conviction petition to the Mississippi Supreme Court. Mississippi Supreme Court notes the video, they note the exonerations that have happened, they note that West has been kicked out of the ABFO, which doesn't kick anybody out, and they conclude, and this is a quote from it, the opinion, just because Dr. West is wrong before doesn't mean he was wrong in this case. So even after all that, they refuse to find anything wrong with what he's done. To this day, Jim Hood, the Attorney General for Mississippi, he does now denounce West, but he still defends convictions won based on West's testimony, in most cases because he argues that the defendants have already argued about West's credibility and were procedurally barred from raising these arguments again, which I'll get to in a minute. Hood did say he was opening an investigation into West a few years ago. About a year later, a defense attorney asked what had happened so far in that investigation, and the attorney that Hood had put in charge of it said that so far he had done a Westlaw search on West's name. That was the extent of the investigation that they had done. I don't want to spend too much time on Mississippi, but what I do want to point out is when all this stuff broke, the defenders of Hayne and West, and particularly of Hayne, would say something to the effect of, and this is true of Hood, this is true of prosecutors across the state, they'd say a couple things. One, they would say he's a great witness, right, which is pretty telling. But then they would also say, well, Mississippi was in a bind. We didn't have anybody to do these autopsies, and Dr. Hayne stepped in, and yeah, maybe he did more than he should have, but he was helping us out, and why should we punish him for that? And what this neglects, or what this overlooks, is the fact that this was all by design, right? There's a time when Mississippi actually had a state medical examiner who was supposed to oversee this process. First was a guy named Lloyd White, who's now in Texas in the early 90s. He was basically chased out for trying to impose some standards on this system, trying to rein in the coroners and the prosecutors. He was replaced by a woman named Emily Ward, who was just completely run out of town. And then the state legislature kept the office vacant for the next 15 years. So there was nobody to even oversee this process. Hayne was basically the de facto medical examiner in Mississippi up until about 2011 when they finally hired a state medical examiner. But this was all by design. Prosecutors didn't want a state medical examiner. They didn't want somebody imposing standards. They didn't want someone making sure that that these medical examiners were doing the appropriate number of autopsies, that they weren't giving inappropriate testimony, because it was helping them win convictions. Defense attorneys are also to blame in Mississippi. Defense attorneys in Mississippi, the public defender system is pretty terrible. A lot of times a defense attorney will get $3,000 or $4,000 to be the public defender for their town or county, which means most of them make their living in private practice. Well, a lot of them make their living in private practice by taking medical malpractice cases, wrongful death cases. If you need a witness in those cases, if you need an autopsy, Hayne was the only game in town. So are you going to attack this guy's credibility in your criminal cases, which make up a very small percentage of your income, when you need him? You need this guy in all of your private practice cases. And this is not true, of course, of all criminal defense attorneys in Mississippi, but if you go back and look through the transcripts, there were very, very few challenges to this guy's credibility in some of the early criminal cases. The only time you really see challenges to Hayne and his credibility in Mississippi are when these medical malpractice cases or civil cases, when the person being sued has enough money to hire investigators and hire attorneys to grill Hayne in depositions. Coincidentally, those are the cases that hardly ever made it to trial. So basically, this guy positioned himself in a way that made everybody happy, or made anybody who had the power to do anything about it very happy. But again, this was the way they all wanted it, right? It wasn't a sort of fluke of history that this happened. This is the way the system was created. So in Harry Blackmun's famous Supreme Court opinion where he denounces the death penalty, Justice Antonin Scalia wrote a strong dissent. And in that dissent, he talks about the case of Henry Lee McCollum and Lee Brown. And Scalia brings up this case, the case from North Carolina, as an example of the worst of the worst. That these are the kinds of people that the death penalty, these are why we have the death penalty. And I believe in this case, this young girl was raped by a couple men. I think her underwear was stuffed in her mouth. I mean, it was a really, really horrible case. And Scalia cites this as a justification for the death penalty and a sort of mocking Blackmun's, coming to Jesus moment about capital punishment. Well, you probably all know where this is going, right? McCollum and Brown were both innocent, and they were later exonerated in 2000, I believe it was 2007 or 2008. There were some subsequent investigations of the North Carolina Crime Lab, and what they found was that in the North Carolina Crime Lab, there was a lot of really perverse incentives had been initiated or had been sort of implemented at that crime lab. Crime lab analysts reported directly to prosecutors. In fact, their year-end reviews, their raises, and their promotions were determined by prosecutors. I'll give you one quote the Raleigh News and Observer found in one of these reviews. It was written by a prosecutor in North Carolina about a crime lab analyst. Quote, "If Lisa Edwards gets any better on the witness stand, the Johnson County Defense Bar may try to get her banned from the county for good!" Exclamation point. The Raleigh News and Observer found a manual that was given to the crime lab analysts about how to do their jobs, right? One of the quotes from the crime lab manual says, quote, about how to be a good witness: "A good reputation and calm demeanor enhances an analyst's conviction rates," right? Referring to the analyst's conviction rates, not the prosecutors, which is, bad enough. They warn crime analysts about defense attorneys who, quote, will try to put words in your mouth in order to raise inaccuracies with your testimony. They refer to crime lab analysts for criminal defendants as, quote, defense whores. This is in the manual that they gave to the crime lab analysts. The paper also found a security video. It's one of my favorite stories from the North Carolina Crime Lab. Security video of two blood spatter analysts doing a blood spatter recreation. And they end up doing it about a half dozen times until they finally get the result that the prosecutor wanted in that case in order to get a conviction. And afterward on video, they're seen high-fiving one another after getting the result they were looking for. Even after all this was exposed, there was severe resistance within the crime lab, the people that ran the North Carolina Crime Lab, to any sort of reform. John Waters, who was the sort of defender of the crime lab, I guess the spokesman for the crime lab at the time, said, quote, "The thing that concerns us most," and this was a proposal for an independent monitor to go in and watch the crime lab in North Carolina to sort of have full access. And he says, "The thing that concerns us most is the precedent this would set and the potential for harm here." Now think about this. This was after about five wrongful convictions that were directly tied to bad forensic evidence. The potential for harm here is not the potential for more wrongful convictions, the wrongful convictions that already happened. It's that our analysts might be, monitored by this independent monitor. We aren't a testing lab for defendants. We are the state's laboratory. Again, sort of throwing aside any notion of sort of objectivity or sound analysis. There's been a little bit of talk today about drug dogs. This is one of my favorite topics. As a dog lover, I'd like to see them be used for good instead of evil. But one of the things that's not really understood about drug dogs, yes, it's true that dogs have this incredible scent. It's been honed by millions of years of evolution. But we've actually bred into domestic dogs an overriding function, which is a desire to please us, right? So when drug dogs or other scent dogs in murder investigations, for example, alert to someone, unless that dog has been trained to sort of trust its sense of smell over its desire to please its handler, you can have real problems. And this can be overt. I mean, there have been cases where handlers have directed their dogs to alert when the dog didn't want to. But it also could just be a matter of the dog reading the handler's language, right? They're very good at reading us. This, again, comes from, generations and generations of breeding this into dogs. The ability to sort of read us, know when we're happy, know when we're sad, to be able to see, if our body language indicates someone's a threat, the dog barks at that person. If our body language indicates they're a friend, the dog won't bark at that person, unless it's my dog. They bark at everyone. So there was actually a study at, I believe it was Columbia, where they found this old church. They brought in 19 dog handler teams, right? And the researchers put packages throughout the church, and they told the handlers, some of these packages are going to have drugs, some of them aren't, and this is just a proficiency test. In reality, none of the packages had drugs, but some of the packages were designed to trick the dogs. They had sausages in them or tennis balls. The other packages were designed to trick the handlers, right? They might have a little white powder leaking out the side, right? None of the dog handler teams got it right. Every one of them, there were false alerts with every single one of the 19 handler teams. Fascinating thing is that the traps that were designed to trick the handlers were 3 times more likely to trigger a false alert than the traps that were designed to trick the dogs, right? So clearly what was happening here is that the dogs were reading their handlers and were alerting when their handlers thought the package looked suspicious. My favorite example of this kind of principle applied in the real world was a few years ago, U.S. Customs or Border Patrol put out this press release celebrating the brilliance of one of these drug detection dogs, because this particular drug detection dog had alerted to a package of counterfeit DVDs. And apparently this dog was so smart that it could actually distinguish counterfeit DVDs from proper DVDs. Never occurred to them that maybe the dog was just alerting to its handler's suspicions about the person who owned the package. I have a lot more examples here, but I don't think I'm going to have time to get into all of them. But one thing I do want to talk about, I'll go back to Mississippi very quickly because I want to talk about kind of the roadblocks that are put in place for defendants in these cases and the way sort of science moves much differently than the legal system. So as we all probably know, the legal system puts a premium on finality, right? Once someone has been convicted, it becomes very difficult to get a new trial, particularly when post-conviction. Science, of course, does not put a premium on finality. Science is continually evolving. Science never, proclaims something to be thus, right? There's always a possibility of sort of revising of new evidence to move us in a different direction. So in 2012, a guy named James Kuhn, was in Louisiana, had been convicted based on testimony from Stephen Hain. He filed a pro se petition in Louisiana. If you're not a capital case, you don't get state-funded defense in post-conviction. So this is a pro se petition, post-conviction petition, and he cites Hain, and he cites a lot of stuff that written about Hain that have been come out in the recent years. And the fascinating thing is in 2014, the Fifth Circuit Court of Appeals, a 3-judge panel, issued an opinion denying him a new trial, denying his post-conviction petition. The fascinating thing about it, that wasn't fascinating, that happens a lot. Fascinating thing about it is what they referred to Hain in the opinion as the now discredited Stephen Hain, right? Well, the interesting thing about that is that's the first time that court had ever declared him discredited. And in fact, in the opinion, they denied the petition not because they didn't sort of do any sort of review of the evidence. They determined that Hain had been discredited for so long now that James Kuhn had missed his deadline under the 1996 Terrorism Effective Death Penalty Act, whatever that was called, had missed his one-year deadline to file a post-conviction petition based on newly discovered evidence. They said, we knew the stuff was coming out about Hain years ago, you should have filed this petition way earlier. Well, the interesting thing about that is at the time, Mississippi Attorney General Jim Hood was still saying in the press that Hain was a credible witness. Mississippi Supreme Court was still saying that Hain was a credible witness. In fact, the court in the Kuhn case in 2014 cited the Tyler Edmonds decision, which came down in 2007, said, well, the Mississippi Supreme Court, throughout his testimony in this case in 2007, you should have filed your petition then. Well, of course, they said explicitly the court went out of its way to say, we are not saying that Dr. Hain is not credible in other cases. This is limited to this case. In fact, in 2009, the Fifth Circuit, another Fifth Circuit judge, not on the Court of Appeals, but a circuit court judge, upheld Hain as a perfectly credible witness in 2009. In 2009, a different Fifth Circuit district court judge upheld Hain as a credible witness. In 2011, the Fifth Circuit Court of Appeals, a 3-judge panel, upheld Hain as a credible witness. So apparently at some point between early 2011, when the Fifth Circuit 3-judge panel upheld Hain as a credible witness, and 2012, when James Kuhn filed his post-conviction petition, Hain went from becoming a credible witness to a not credible witness. And according to this Fifth Circuit panel, James Kuhn was supposed to know at exactly what date Hain was no longer a credible witness, so at what point the sort of tide had turned, right? Now, the court, of course, never made a formal announcement or put out a press release. It was just up to him to know when Hayne was no longer a credible witness. That would be all bad and terrible in and of itself. But remember, I said James Kuhn filed his petition in 2012. Actually, in 2013, a year after he filed his petition, a year before this decision comes down, the U.S. Court of Appeals for the Fifth Circuit, same circuit, issued an opinion declaring that Hayne was a perfectly credible witness and that they were not going to throw out his testimony. So you can't even say that he should have discovered it in this very short window, right? Because they actually issued an opinion after that. Here's the remarkable thing. One judge, I have his name on here, Grady, I believe was his name. Jolly Grady, yeah, was on both panels. He was on the panel in 2013 that declared Hayne a credible witness, and he was on the panel in 2014 that not only said that Hayne was no longer credible, but that James Kuhn should have known by the time he filed his petition in 2012 that Hayne was no longer credible. My point here is that the way the courts have been set up, the way that this 1996 law has been set up in post-conviction cases, it makes it impossible for people in these cases, particularly with a case like Hayne, where there's sort of this slow trickle of information about the fact that this person is discredited, but also in cases like shaken baby syndrome, where the courts were very quick to allow this evidence in at the trial stage. Very slowly, over the next 10, 15 years, the scientific consensus slowly changes. But if you're a person who is convicted based on this evidence, you have 1 year from the point where you've discovered this newly discovered evidence to file your post-conviction petition. Well, the other problem with that is that in a lot of these cases, people did actually challenge this evidence at the trial stage, and they were denied. And if that happens, and then if that happens, and then more evidence comes out later, further sort of proving that you were right, you're now procedurally barred from raising this issue again. And this has happened in Mississippi. Lots of people have tried to raise the issue of Hayne and West after the fact, even though they did challenge their credibility at trial. Mississippi Supreme Court has said, no, that you were denied. You're now procedurally barred from raising this again. So you can see in these cases, it puts defendants in a pretty bad predicament. There's no real sort of guidance about when you can file these petitions. There's no guidance about when science has officially sort of proven that this forensic discipline is no longer science. And there's no clear guidance on this at all. How long do I have? Can I get? Okay, 15 or 20. Okay. So a lot of the bite mark stuff was covered by Chris Fabricant earlier. There was one moment when someone, I believe, from one of from the Forensic Science Commission had said something to the effect of, everybody in this room knows at this point that bite mark evidence is bogus, that there's no science behind it. And it struck me kind of at the time as pretty remarkable, because I'm guessing it's probably true. And yet, as Chris Fabricant pointed out in his presentation, not a single court in the country to date has upheld a challenge to the legitimacy of bite mark evidence. So it's as good a testament to the fact that the courts just don't get this, that the judges are asking judges to be the gatekeepers of good and bad science, just hasn't worked at all. Chris also talked about this idea of how you define sort of the relevant population of scientists when you're just trying to decide under Daubert or under Fry if this sort of discipline is widely accepted in the scientific community. And the Clarence Dean case in New York is a good example of how this sort of plays out. New York's still under the Fry standard, I believe, but in that case, Melissa Morgus, this really awful prosecutor from Manhattan, had argued basically that the relevant community of scientists when you're evaluating whether or not bite mark evidence is legitimate is other bite mark evidence, and she won. The judge in that case actually ruled against the challenge to bite mark evidence. But as Michael Sachs, the forensic specialist, told me when I interviewed him for an article I wrote, he said this is sort of like saying it's sort of like trying to evaluate the legitimacy of tarot card reading and only interviewing a population of tarot card readers, right? Of course they're going to say it's legitimate. You have to sort of go outside that community to get a more objective analysis. In Sachs, back in the 70s, there was a area of forensic analysis called voice print technology that the FBI was pushing. There's this idea that we all have a very unique voice, and you can do sort of an audio or a sort of visual rendering of your voice, and everyone's voice will be unique, and we can say that this is this person's voice to the exclusion of everybody else. It was junk science. It was crap. And it was eventually, the FBI stopped using it and courts stopped accepting it. But Sachs did a study or a sort of an analysis going back and looking at these cases. And when there were challenges to voice print technology, what he found was almost unanimously, when judges limited the population of the sort of relevant scientific community to other voice print analysts, they determined that the voice print analyst in this particular case was legitimate. Also, almost unanimously, when the judge looked beyond the community of voice print analysis, they determined that the voice print analyst in this particular case was not scientifically legitimate. It's sort of intuitive to say this, but it's actually some practical actual data out there that when you open up the community to sort of the entire scientific community and not just these sort of narrow fields of forensics, you get much different results. So, final thing is I want to throw out some ideas kind of for reform, since I have your ear for another 5 or 10 minutes. A lot of the ideas I have on here have already been mentioned, of course. Sequential unmasking is a big one. Analyst independence, the idea of not having crime labs report to state police agencies or prosecutors or the Department of Public Safety, of sort of being independent in their own right. Statistical analysis, I think it was Harris County, actually, in the early 2000s. There was one analyst that was diagnosing shaken baby syndrome and infant deaths at a rate sometimes something like 10 times the national average, and that sort of exposed her. More of that. Competency tests. My favorite sort of examples in the bite mark story is that the ABFO administered a internal bite mark exam to its own members, and what they found, and they weren't even asking them to sort of match a bite to the person who made the bite. They were just asking the members to say, is this a bite mark and was it made by a human? And they couldn't even get their members to agree on that. There's no reliability even on identifying whether it was a human bite mark or not. And the really fascinating thing is the more experienced the bite mark analyst, the more likely they were to disagree about whether this was a bite mark or not. I think those kinds of tests can be very revealing, probably not in the way the ABFO wanted in that particular case. But defense access to experts is huge. I think some states that actually have one-to-one requirements that whatever the prosecution spends on expert witnesses, the defense is supposed to get that much money. I can tell you in Mississippi, go back to Mississippi again, in the Jeffrey Havard case, it's another Hain special. Havard is actually still on death row in Mississippi. Was sentenced to death in a shaken baby syndrome case. During the trial, asked the court for funds to hire his own expert. And the trial judge said, Dr. Hain's done thousands of autopsies. The crazy thing is when he gets challenged, the judges in Mississippi actually refer to the fact that he does 1,700 autopsies per year as evidence of how good he is at what he does. Anyway, Havard was denied. He was convicted. Post-conviction, he gets a couple of other medical examiners to review Hain's autopsy, including Jim Lauritsen, the state medical examiner in Alabama. And Mississippi Supreme Court remarkably says they're not even going to read these affidavits from other medical examiners because this is evidence that should have been introduced at trial, right? Well, of course, he tried. The court wouldn't give him funds to hire his own expert. It's a great example of sort of the Kafkaesque kind of dilemma that these courts can put defendants in. I also think analysts should be free to testify for the defense. They should be free to contact the defense if they have problems with the way sort of a prosecutor is handling a case or the way the police are handling a case. Emily Ward, the former state medical examiner in Mississippi, one of the reasons they sort of ran her out of town was because the prosecutor had asked her to do an autopsy in a case. She did it. She came up with a conclusion he didn't like, so he took the body to another medical examiner and never got back to her, didn't call her as a witness, so she reached out to the defense and said, hey, look, I think there's something wrong here. And this was like the biggest sin she could have possibly committed. There's a prosecutor in Minnesota a few years ago, basically tried to get a crime lab, I think it was a medical examiner, barred from ever testifying in Minnesota again because she had the gall to testify for defense attorneys in another county. This sort of betrays the idea that the analysts work for the state, that they're part of the prosecution's team, right? If we bar them from ever sort of reaching out to the defense or testifying for the defense. But the one thing I want to promote that I don't think I've heard discussed today, a guy named Roger Koppel, an academic, I think he was at Fairleigh Dickinson for a while, I can't remember where he is now. But it's this idea of rivalrous redundancy in crime lab analysis. And the idea here is that when the incentives are wrong in a crime lab, the cognitive bias problem, the best way to do that, and the best way to root out rogue analysts and sort of corrupt analysts, is to provide some sort of check against them and sort of reverse the incentives. And you do that, the idea here is in a state or given jurisdiction, you'd hire an evidence handler. And basically what happens every 2 or 3 or 4 or 5 or 10 cases, the evidence would be taken to a separate crime lab for an independent analysis. The people in the official crime lab would never know in what cases they were being double-checked by someone else, right? So it would be completely blind. And you do that, and suddenly sort of the incentive changes, right? Now you're not so much worried about pleasing, the prosecutor because they're doing your review, or the sort of maybe implicit bias that comes with thinking that you're part of the state's team. Now the incentive is to not embarrass yourself, right? You want to do every analysis right every time because you may be checked and you may be called out by this other lab at some point. And Koppel did crunch some numbers and figured that, for the costs of about 2 wrongful convictions, when you factor in, compensation, a state could implement a rivalrous redundancy program for about 5 or 10 years. So that's one an idea that I think hasn't been mentioned much today. There are other proposals that are much less likely, or sort of more. There are more political obstacles to. Of course, the big one is making judges the gatekeepers of science, and this has already been discussed today. But the idea that somebody, who's spent their entire life in law school or in academia, law academia, that they can sort of, provide a scientific analysis of evidence that can be quite complicated sometimes. It's just makes no sense at all. Sachs, when I interviewed him for a couple of articles, so he sort of likened it to the answers he would get on exams that he would give to undergraduates when they sort of knew what the right answer was, but they didn't know how to get there. He says when he reads some of these sort of opinions in Daubert cases or Daubert challenges, that they read like the judge already sort of knew what they wanted to say, and then they sort of write backwards to get to that conclusion. And of course, that's not how these analyses are supposed to be done. The question is who does decide that, right? Do we put a blue ribbon commission together to decide what evidence? And in terms of like excluding bite mark evidence or putting limits on other pattern matching evidence, that may make some sense. But in terms of a medical examiner like Hain, where he's given bad testimony in some cases, completely plausible testimony in other cases, to have sort of a commission review medical examiner's testimony in case after case after case just doesn't seem practical. So some of these solutions or some of these ideas are more difficult to solve, I guess, than others. A couple of the main things. I think the federal habeas process needs to kind of reflect evolving science and the problems that we're having in forensics. The Anti-Terrorism and Effective Death Penalty Act, that's what it's called, I have it written down here, should be repealed. I mean, that law puts up way substantial hurdles to even getting heard in a lot of these cases where it's clear that the science has changed. There are states that have even sort of higher hurdles to getting new hearings and new cases in some of these forensic cases. A good example is in California, which is was it Richards? Is that Chris, the Richards case in California? Yeah, so this is the case where this guy was convicted based on bite mark evidence. The bite mark analyst was testifying, claimed he could match the guy's bite mark to this blurry kind of photo from the crime scene. Well, after conviction, 5 other bite mark analysts refute his testimony, including the guy who originally testified against him. And yet the California Supreme Court, this was not enough to give Richards a new trial. A blurry photo is enough, evidence or testimony based on a blurry photo is enough to give him to get him convicted. Testimony of several other experts, including the expert who testified against him at trial, refuting his own testimony, is not enough to get him a new trial. That's a problem, right? And it shows just how difficult it can be once the system has decided that a verdict needs finality. The last thing I'll just say is I had an interview. He decided he did not want to be interviewed for attribution after we talked. But with I'll just say it's a sort of prominent person within the forensics community, within one of these forensic organizations. And in the interview, he sort of cautioned about moving too fast on forensics reform. Basically, he said that we got into this problem because we moved too fast and thoughtlessly. We can't try to get out of it by moving too quickly. We need sort of deliberation and careful thought and consideration. And the problem with that is that the damage from those initial bad decisions that got us here in the first place is ongoing, right? These people are still in prison. There are people still suffering. There are people still being convicted. There was a conviction in Maryland last week in a shaken baby case, right? Even despite all the doubts, the fact that people are getting released because of shaken baby testimony. So, I think that we need to act, with a sense of urgency. I realize that there are a lot of constituencies that have a lot of input in these decisions and what reforms are going to be made. But I do think the NAS report was great, but I think in many ways it was way too diplomatic. It gave a lot of cover to judges and to prosecutors who sort of wanted to, again, Chris can talk about this, but Melissa Morges, as prosecutor in Manhattan, would sort of take passages from the NAS report because it left just a little bit of wiggle room here and there, and blow them take them completely out of context. I think we need to speak sort of in more absolutes, particularly on disciplines that have no sort of basis in fact whatsoever, or scientific fact whatsoever. Overcorrection is always a risk, but the system has been, sort of hemorrhaging for years. DNA testing has finally allowed us to see that, but we can't worry about sort of over-medicating the problem or overreacting to the problem when we haven't yet even stopped the bleeding. Thanks for asking me to talk today. I'd be happy to take questions. No questions? Yes.
Radley, were you in Orlando last year?
No, I was not. Well, I was at the Innocence Project event. You're talking about the AFS?
Yeah, and there was the guy. I think Chris was there too. The New Mexico medical examiner. Yes, Ross. Yeah, thank you. So he took the position that medical examiners cannot be. Thank you for those watching on the web. Okay, medical examiners cannot be subjected to sequential unmasking or any blind information because they have a legal duty to make a determination. And the example he gave was, I've got a young man on the slab, got a gunshot wound to the head. How am I supposed to tell whether that's a murder or a suicide if you don't let me, if you don't have the police officer tell me that you found a note next to the body?
Right.
And I certainly had a strong reaction to that. I'd like to hear yours.
Well, yeah, so the job of medical examiners is to determine cause and manner of death, right? And I think the key to that is keeping those two things separate. I think you can determine cause before you get to manner. And maybe manner requires some input, but I think you have to be very guarded about it. I mean, there's a great Hain autopsy where the mother was accused of killing the daughter. There was really, the daughter, I think, had slipped and hit her head, and there's no real evidence on the body to indicate that this was a murder versus an accident. But Hain, in the manner, he determines that this was a murder or homicide. And the reason for it, he says, see sister's statement, right? That was his reason for determining that this was, and that's not for a medical examiner to determine, right? That's for a jury to decide. I mean, that's something that there's no sort of unique qualifications of being a medical examiner that allows you to read a witness statement and decide that that's how the person died. What was just curious? What was your reaction?
I had the same reaction. The problem we get is we get a medical examiner's report in a case like that, and it says the cause of death, suicide. But there's nothing in the report that indicates whether the determination of suicide was based from what the medical examiner saw in the brain or from the outside information. And so my position is that it would be fine for the medical examiner to get that information after determining the cause of death or the manner of death, and then say, but based on the additional information, such as the note I was handed by the deputy, I hereby discharge my legal obligation and declare this to be a suicide.
Right.
And I just can't understand why there's such resistance to having that kind of separating out what you can tell from the science versus what you can tell from the outside information.
Absolutely. And Hain, and I've seen this in other medical examiners too, will go even further to they'll say, the defendant claims that he was on the ground shooting upward at the victim, that couldn't have happened because the bullet trajectory, is taking a downward angle through the body. Like actually speculating on the position of the shooter based on the trajectory the bullet took to the body. Well, if a body's crouching, if it's, the angle that you're holding the gun, I mean, there are so many other variables that can go into a trajectory of a bullet. But to be able to sort of claim that just by looking at this body on the table, I can tell where the shooter was, how the gun was pointed, without even knowing the position. I mean, I think there's a strong argument for saying this is how the person died, like this is the cause. And then, maybe even it shouldn't even be the same person who determines manner. I don't know. Maybe that's a little radical, but, it seems like it's something that should be at least a separate determination.
I just had another reaction to that, which I agree with what you're saying here, but it seems to me that it needs to be not just a separation in the stages of the analysis at the autopsy, from the looking at the medical signs to determine cause of death, and then because the medical examiner has the statutory obligation to determine manner of death also, then to allow him or her to consider all this extra stuff. That makes sense to me to break that into the two parts, but then I think we also have to be careful to break that down when the case goes to court, which is to say, then the medical examiner testifies only about the medical science part about cause of death and can't even say a word about manner of death because that's for the jury to determine based on the note and all the other stuff.
Yeah, I think that's a good point. And I've actually made this case before. I'd go even further. I think in cases, I think there's a strong case to be made to have bifurcated trials in cases where it's not even clear a crime was committed. So shaken baby cases, arson cases, because when you walk, when the question isn't who committed the crime, but whether a crime was committed, and the jury walks in and they see a guy sitting in a chair, and he was the last person who was alone with the child, that's already suggesting to them that a crime was committed, right? Because there's a guy sitting there who's accused of it. And if a crime was committed, then only that person could have done it. So I think there's a strong case to be made in a lot of these again, shaken baby, cases where you're wondering if there's an accident or if it was intentional, arson cases, of having an initial trial to determine whether a crime was even committed, and then, if a jury decides that, then you move on to who actually committed it. Just an idea.
Hi, I wanted to keep sort of pushing on this line and actually sort of scope beyond forensics for a minute, because this is in part about innocence. And you started your remarks actually by saying, how can we learn more to help inform better practices in the cases that we're not necessarily seeing through the lenses that we have to apply to them. And it just strikes me that like the broader concern here, right, is about sort of contamination of evidence, right, and the kind of contamination where we have a hard time sorting out whether it's in fact the scientific expertise that's informing the conclusion, or it's the outside input of motivated investigators, or it's the internal motive of the actor anyway. And the same could be said, right, about lay witnesses that are testifying at trial, or the reports of lay witnesses before trial, right? Mm-hmm. It's incredibly difficult. You're probably familiar with some of Dan Simon's work on this, right? Incredibly difficult to know to what extent their memory that's being conveyed is really what happened, or whether it's the product of, right, as people were talking about earlier, the impressions that were given to them and piecing together through time. And I just wonder whether at the end of the day we should actually treat science as so special in this regard. Why are we taking so much more care, in other words, in terms of the integrity of the scientific evidence, and sort of leaving in its relatively crappy state, right, the status of police investigation, which is to say not just, hey, maybe IDs should be double blind, or maybe you should write down what you're doing in your reports, but should we be thinking about the whole investigative apparatus really not being appropriately situated within this kind of adversarial motivated process? Should it be magistrates doing the whole thing from top to bottom? I just want to see how far you would want to push it system wide.
Yeah, I mean, I have kind of at time to time entertained the thought of and maybe there are going to be some gasps at this, but of full-time juries. I mean, I think a lot of these forensic specialties are so complicated, particularly when you talk about trace DNA. The calculations involved in some of those cases. The new book that just came. Yeah, gets into a lot of that. Maybe there is a case to be made for that. I mean, they'll probably require amending the Constitution, and we're getting pretty far into the weeds now. But I think these are things we do need to think about. I mean, this is kind of like a once and forever opportunity, right? I mean, DNA has exposed all this. Like all of a sudden, we're open to the possibility that our system is, not nearly as adequate even as we thought it was. What do we do to fix it? And I think, if ever there were a time to entertain some of these kind of more radical notions, now would be the time to sort of discuss them, I think. Great.
Okay, join me in thanking Radley Balko. We'll take just a 5-minute break. We're a little bit behind schedule, but not too. So take a quick break and come back as soon as possible for panel 4.